Now we're switching gears from the the more of the technical and rock, going into the insurance sphere of things. We'll have two speakers. First will be Rob McLeod. He's an account executive with Metrix Professional Insurance Brokers. He's a member of the Access Insurance Group with nearly 10 years of risk management experience. As a professional liability insurance broker, he specializes in assisting architects, engineers, and construction professionals manage their risk exposures through education and quality insurance solution. Rob's an active member of the design professional community and regularly publishes articles related to loss prevention. He holds a Canadian accredited insurance broker and chartered insurance professional designations with focus on commercial risk management and business interruption. He'll be joined by Karen Weslowski. Karen practices insurance, defense, litigation, construction, and commercial litigation. Her clients include a wide range of professionals, insurance brokers, manufacturers, land developers, contractors, and others. She has represented clients at all levels of court, including the BC Supreme Court, the British Columbia Court of Appeal, the Federal Court of Canada, and the Supreme Court of Canada. With that, I welcome both Karen and Rob to the stage.
Thank you, Olga. My name is Rob McLeod. I'm from Metrix Professional Insurance Brokers. Our team helps a few hundred design firms in BC manage their liability risks through workshops like this, contract reviews, and on-the-go advice for addressing unique circumstances to hopefully prevent actual claims from occurring. Today, I've partnered up with Karen Weslowski from the law firm Thomson, and we are going to review 3 claim case studies and some risk management strategies for avoiding potential claims. And we're also going to touch base on the claim process. So Karen, the stage is yours.
Great, thanks, Rob. And thank you, Olga, and everyone, all the attendees for inviting me to speak today. I'm very pleased to be here. And we have to start with a bad lawyer joke. So hopefully everybody can see that on the screen. So I often have this discussion with my clients about construction being a prelude to litigation. So that the comic says build it and they will sue, which seems to be, it's a joke, but it's sometimes the unfortunate and sad reality of construction these days. Litigation almost seems inevitable. So in our presentation today, we are going to go through the litigation risks that arise, particularly in the context of geotechnical engineering work, which does tend to face disproportionate risks in some respects. We will talk about the ability of a geotechnical engineer to engage in appropriate risk management techniques. That often depends on the willingness of the owner to participate in those techniques. And one of the major issues is funding to do adequate subsurface investigation. So we'll talk about how to work around that issue if it's possible. And obviously, as you all know, geotechnical issues can result in expensive problems and large claims. Oftentimes, geotechnical issues don't become known until the end of the project when the structure or the project is complete. And by that point, the costs have been incurred. And so as we point out, and as we'll discuss in the presentation today, it is difficult to eliminate risks entirely, and it wouldn't be realistic for either Rob or I to tell you that we have the magic bullet for eliminating claims. But ideally, they can be managed through good practices, insurance, and in some respects, using particular types of contractual terms. So as Rob mentioned, we're trying to keep this session practical. And so we have 3 case studies, which are going to illustrate issues that arise in the context of claims management and risks that are commonly faced by geotechnical engineers. So we'll look at what those issues are and what the resulting legal issues are. We'll look at risk management steps. What can you practically do to try to reduce the claim or deal with the claim that is inevitably going to result? And we will review how insurance and contractual terms may or may not be an effective form of risk management. And then, as Rob mentioned, we'll also briefly review best practices in the management of claims. And we are mindful that we only have 45 minutes today. So we did prepare a very detailed paper, which I understand is available on the website. And it sets out the case studies and all of the discussion that I'm going to go through. And I will talk about the law and talk about some of these issues. And then Rob is going to jump in with his comments on the insurance side and also other practice points that he's garnered in his years of experience in dealing with these types of claims and geotechnical professionals. So the first case study, I'm not going to read it all, I'm just going to summarize it for you. All of the case studies that we're using today are taken from real world examples. The names and some of the identifying facts have been removed to protect the innocent or the guilty, as it were, so that people can't necessarily identify where they came from. The first case study deals with a situation that potentially many people here have encountered with respect to the difficulty of getting owners to fund adequate subsurface investigation. So in this case study, there was a geotechnical engineer who was retained to do a preliminary geotechnical assessment of a proposed residential subdivision. He was a very experienced geotechnical engineer with over 30 years of experience. The subdivision site was relatively large, about 20 acres. It was sloped. There was some water features there, so it may have been a bit of a challenging site because of that. The developer, unsurprisingly, didn't want to incur significant costs in relation to subsurface condition testing. So the geotechnical assessment was one, attendance by the consultant to do a visual site reconnaissance, and the excavation of 3 test pit holes along an old road that ran along the site. So the geotechnical engineer relied upon the site visit, the test pit holes, and his experience, and ultimately concluded that it was appropriate for residential development. And then during site prep and construction of the subdivision, there was geotechnical occurrences like tension cracks and sinkholes that developed. And the geotechnical consultant retained a sub-consultant to provide a second opinion, who concurred with the geotechnical's opinion that it was still appropriate to develop as a residential subdivision. And after construction of a few houses on the subdivision, there was a sinkhole on the property. And unsurprising to no one, the property owners sued the developer, geotechnical consultant, and the geotechnical consultant who provided the second opinion. So this is a fairly complicated fact pattern in that it raises a significant number of legal issues. And the issues I've identified here are discussed in more detail in the paper. And what I'm going to do is I'm going to take each bullet and then flesh it out based on comments that I have in the paper. So if you have any further questions, it'll be in the paper. So I'll try to just take each bullet and then have a discussion about the issues that arise. So the first issue that I have there is the duty to investigate and the standard of care. I think everyone is probably familiar with that concept, so I won't spend too much time on it. It's obvious that the geotechnical engineer is under duty to ascertain soil conditions that are relevant to the foundation of the structure or building being determined insofar as reasonably can be determined. And if there's a failure to conduct sufficient testing to ascertain the subsurface conditions, the court will most likely find that the geotechnical consultant was negligent. And unless your contract states otherwise, if you've contracted to a higher standard of care, which is not recommended, the duty owed by the engineer is to exercise the skill, care, and diligence, which may reasonably be expected of a person of ordinary competence measured by the professional standard of the time. And that aspect, or the element professional standard of the time, is very important because the engineer is to be judged based on the state of the art and the industry standards and the knowledge at the time that the work was done. So it's not appropriate to import a backwards hindsight analysis into the standard of care. Say, for instance, if technology evolves and it becomes known that there's different technology to determine conditions and a better means of ascertaining soil conditions when the claim is around or when the claim is made, but that wasn't in existence at the time the work was done, you can't use that newer standard. And the standard of care will also be judged relative to the context of the project. So this is a residential development. What is reasonable for a residential development and what is reasonable for the relative complexity of the site. So it may vary depending on the complexity of the site. And the second bullet there is to what extent a geotechnical engineer can rely on their experience alone in lieu of subsurface testing. The case law has recognized that out of all the engineering disciplines, geotechnical consultants are the ones that have to rely the most on their professional judgment and expertise, because obviously you're just taking samples and using that representative sampling to extrapolate as to what is under the surface of the soil. I mean, short of excavating the entire site, you're not going to know what's there. So the courts do respect and understand that judgment is an element, and so they will respect the geotechnical consultant's experience. However, experience should not be relied upon entirely to determine the adequate subsurface conditions or the soil conditions. I mentioned this in my paper. There is an old Alberta case from 1917 where the court said that a geotechnical consultant who relied solely on his experience was not negligent because he had a lot of experience in that area and had adequate character or adequate knowledge of the character of the soil. I'm not sure if that case was decided today that the court would come to the same conclusions. I suspect in 1917, although I'm not a geotechnical consultant, so I can't say this for certain, but I suspect that technology has evolved since then, and presumably subsurface testing methods were less sophisticated and potentially less readily available. So it may have been reasonable at that point in time for a geotechnical engineer to rely on their experience when no other means of testing were readily available. So it's a bit of a contextual analysis as well to what is reasonable in the circumstances. With the state of modern technology today, I think you could probably argue that there's probably going to be limited circumstances where subsurface conditions can't be ascertained. The bigger question will be what is reasonable in the circumstances. So reasonableness will be judged in relation to the size of the project. The next bullet there is how to deal with a geotechnical, or how to deal with a client rather, who does not want to engage in sufficient subsurface testing. I'm sure this is probably a situation that has come up for many attendees today. And it's probably a relatively common situation that unfortunately doesn't have any easy answers. The most obvious answer to that is where the developer doesn't want to undertake any or sufficient subsurface testing. There's clearly a duty on the geotechnical consultant to warn the danger involved in proceeding without doing the adequate or necessary testing. So such warning should be in writing and should fully disclose to the client all possible adverse consequences. And I think, Rob, you have had some experience with this in dealing with having your clients provide warnings and how they can do that in a way that doesn't necessarily alienate people on the project.
Yeah, just you just need to be mindful of it. There's not much more I can comment.
Right. Okay. So obviously, any opportunity you have to do a warning will be helpful, provided in a letter to the owner, a letter to the developer. Make sure that you clearly set out the potential adverse consequences.
Well, and in that case too, we do a lot of claim case studies, and a common theme across them all is people missing opportunities to voice concern and document concern and pad your file. And the more that you can do that, Karen, you can attest to this, the better case that you'll have to defend yourself. And so, and if there's a pre-construction meeting and you have an opportunity to make a comment there, make sure that the concerns raised in the meeting minutes. Afterwards, if you have a phone call with somebody and you've also voiced a concern, make sure that even like a handwritten note in the file that somebody can find later on, or follow up with an email voicing concern again. And so on. So, oftentimes, right there's 2 or 3 times where you could have raised your concern. And, unfortunately, a lot of the time, people don't take advantage of those opportunities. And if a claim arises and they're looking in hindsight of what they could have done, those are the items that they really wish that they took advantage of.
Yeah, it's very true. And I think I give this advice to clients and junior lawyers here, and it applies to every professional. I think if it isn't in the file, it didn't happen. So that's just the safe way to proceed. I mean, you could say it happened. You could say, well, I verbally told them, which may be the case. And it doesn't necessarily mean that that type of evidence has no value, but it's a lot easier to defend claims if you have something that's in writing and very clear and provided to everybody.
Yeah, there's a saying in our industry, and it's, the person that has the most paper wins. And so if I know that the VP of one insurance company, she's walked into certain meeting rooms, and if our client that day has one piece of paper and that's their case, and the opposing party has a complete stack of a well-documented file, they're going to take a different position at that, and they may just say, let's just settle because we don't have a case here. So,
yeah, this is very true. So if you have provided a written warning to your client and the developer insists on continuing without doing what you consider to be sufficient subsurface testing, there's a couple options, and whether these are realistic or not depends upon your relationship with your client and your leverage and the circumstances. So one option is to request a release from the client, releasing you from any damages or claims that may arise from the owner's or client's failure to take your advice. You can request an indemnification from the owner or the client in the event of a claim. So as I said, these are kind of like probably nice to have, maybe a little bit on the idealistic side to think of whether that's actually possible, but it depends on the relationship that you have with the developers. It's something to worthwhile considering to see if it's possible, if it can be negotiated. The last option, if you've provided advice.
Aaron, I'll just back up there. I could see a lot of professionals being in a circumstance like that and saying, hey, how can we protect ourselves contractually? But, how would they go about executing that? At the exact same time, what if the developer and if the case may be, is reluctant to provide a waiver or sign a waiver? What does this process look like? Do they send an email to somebody just saying that they're going to waive liability, or is it like an addendum to the contract? And what if the other party's not willing to participate?
Yeah, those are all valid questions, and it all turns on the specific facts. So if that situation does come up, I think at that point, it may be worthwhile to have a chat with the lawyer and see what could be negotiated. I have done that with certain clients in other fields, like for instance, a building envelope consultant, where the client didn't follow their recommendations. And we did manage to negotiate a limited form of indemnity with respect to potential future claims for not following the building envelope recommendations. So it is possible. Like I said, it kind of depends on the relationship, but it's something to think about. And if you're not able to do that, and say you've got a situation where you provided warning that there needs to be more subsurface testing done, and the owner doesn't want to do it, the last potential option could be to walk away from the project, terminate your contract. Subject to your contract terms, you could potentially be giving rise to a breach of contract claim. So again, you want to think about that carefully, and obviously depends on the particular circumstances of what your contractual terms are.
Yeah, and I can comment on that too. Nobody enters into a project ever thinking that they're going to want to walk away, especially at some of the larger projects that I know a lot of the attendees here work on. But the issue, or I've been seeing the issue come up more and more year after year, where I'm getting phone calls from clients on decent sized projects saying, Rob, this project has changed, or the scope has changed, for a number of different reasons. And, we need to look at, or at least consider what are the ramifications around walking away? And as Karen said, if you don't have conditions in your guys' service agreements to do that, well, then it's going to make it a bit more challenging. So when we do contract reviews for our clients, especially if it's a client drafted agreement, your clients will often provide conditions for them to terminate, but I'll be silent for you to terminate, which means that you essentially can't. So, making sure that you guys at least, it's a mutual termination. If they can terminate, you guys can terminate. So it just provides you with that extra option or potential leverage if you do get in that position. There's other issues around that too. You're not getting paid and termination and relating it to suspension of fees. I'm diving more into a legal world here, so maybe Karen can talk about that later if anybody has questions about that.
Yeah, no, those are all very good points. And we will, in one of the case studies, talk about standard form contracts and potentially one-sided terms. So that's a little window into the future here. And then the last point that this case study raises, just covering it quickly, is the sub-consultant. So if you retain a sub-consultant, you retain the liability for the soil conditions and ascertaining the soil conditions. You're not going to offload liability onto the sub-consultant if you have retained them. So to mitigate risk, what you would want to do ideally is to ask the owner for the authority to retain them on behalf of the owner. So you set up a direct contractual relationship between the owner and the sub-consultant. That's preferable because then the owner can sue the sub-consultant for a breach of contract or negligence. So then that takes us to our next case study. And this is a long one. I'll just summarize the facts. So it deals with the construction of a dam. And I believe this is from a case in the States. And so this involves an earth dam that was built in a canyon to prevent a community from flooding. The community had a history of flooding. And so they hired an engineer to construct the dam. 5 years after construction, the dam failed, caused widespread damage, killing 3 people. It was a farming community, so there's livestock that was dead. It disrupted business. The engineer had hired, or rather the city had hired the engineer with a standard form contract that included kind of a strange term that the dam was intended to prevent the community from future floods and crippling economic losses. And the engineer represented and warranted that his design would address these issues. The engineer used the wrong methodology to design the dam, and ultimately it went to trial, and it was held that the engineer didn't have adequate skill or knowledge to design the dam. The other side's expert would have designed it differently, substantially higher. So the obvious issue that arises from this fact pattern is being mindful of the limits of your expertise. Don't accept retainers beyond the scope of your professional expertise. The more nuanced issues that are raised in this fact pattern deal with the standard form contracts and also the question of the standard of care, whether it varies. And the issue of standard form contracts it's an interesting issue, and it's quite complicated. It's discussed in detail in the paper. And obviously, people here deal with standard form contracts fairly regularly. And one of the issues that comes up is if you have a standard form contract, whether you have any ability to negotiate it, right? Say, for instance, by putting in a limitation of liability clause. For example, in this particular scenario, the engineer might have benefited from a limitation of liability clause that limited the city's damages to not being able to collect consequential damages or like loss of profit. So practically speaking, I think it's probably difficult or impossible for a lot of consultants to negotiate their clauses into large contract projects because the governments or very large corporations use a standard form contract and they generally hold all the bargaining power. So it is difficult to negotiate favorable limitation of liability clauses into those contracts. You may also be responding to a request for proposal, which uses standard form contract. And in those circumstances, there's little to no ability to negotiate the contract terms. So if you're approaching it from that perspective, you think, well, how do I mitigate my risk and how do I manage potential risks when it's a potentially one-sided contract that I have no ability to deal with? So before we talk about that, though, I think it's important to say that standard form contracts are not always bad, and it doesn't inherently mean that that you shouldn't sign a standard form contract. It depends on the standard form contract that is being used. There's some standard form contracts like the CCDC contracts or those published by the Association of Consulting Engineering Companies, which are intended to be fairly balanced and provide a level of certainty and understanding for all the parties as to what the terms are. So those types of standard contracts are intended to be fair and allocate the risk in a reasonable and commercially logical manner. I think you want to be more leery of contracts, standard form contracts, if they're, say, not a CCDC or not an ACEC and something that maybe the owner or the municipality or the corporation has drafted, and they're not sort of like a form of published standard form contract. So issues with standard form contracts arise when the risk is unfairly assigned or improperly directed to the consultant or the contractor rather than the owner. Say, for instance, the standard form contract doesn't limit the consultant's liability to the limits of the insurance policy. Why, for a public policy reasons, should the consultant have to bear the liability exposure beyond the limits of their insurance policy? So that's arguably fair and unreasonable. So an owner that presents a standard form contract or a company that uses a standard form contract has to realize that those contracts could potentially be challenged as being what the court calls unconscionable, which is an issue that has been canvassed recently by the Supreme Court of Canada in a case involving Uber. It's not a construction case. This was a case brought by an Uber driver who challenged the arbitration provisions in his contract of service with Uber. So it was an onerous arbitration clause. He had to negotiate or had to bring an arbitration in Holland, and he had to pay $14,500 US in order to have this right of arbitration. So the issue of unconscionability, whether that term was unconscionable, went all the way to the Supreme Court of Canada. And the court talked about what is unconscionability. And the essence is that it requires an inequality of bargaining power and a resulting improvident bargain. So the upshot of that decision for the construction industry is that we potentially may see more parties trying to rely on unconscionability in an attempt to set aside a standard form construction contract. This decision hasn't been applied in the construction context yet, but it does confirm a few important principles. The court talked about standard form contracts like CCDC, CCA, OA, AA, and RAIC standard form contracts, and sort of said those are generally understood, they're generally balanced and reasonable, and they're probably not going to ever be subject to a finding of unconscionability. Where the parties start to monkey around with those contracts and change the terms and make them lopsided and onerous, those could potentially be open to a finding of unconscionability. Some other practice points from that Uber decision that I think are helpful for people in the construction industry. If there's a document like a prime contract being incorporated by reference into the contract, the party presenting the contract should always ensure that the incorporated document, like the prime contract, is attached. So say, for instance, you're signing a contract that says the terms of the prime contract are incorporated by reference into your contract. You better get a copy of the prime contract to read it to see what it is that you're agreeing to, because there may be terms in there that are not favorable or that you just need to understand. The Uber decision also confirmed that parties who draft their own contracts should ensure that the other side has ample time to review the contract, try to avoid the use of fine print, and make sure that if you have a one-sided or onerous contract term, it has to be expressly agreed to. And if it's your contract and you've drafted it and it's one-sided and the other side didn't have a chance to negotiate it, it's what the law calls a contract of adhesion. And if there's any lack of clarity in the contract, it will be construed against you. So you want to be mindful of that. So there's lots of issues with respect to potential standard form contracts. Like I said, there's more reference in the paper as well too, if anybody has any further questions about that.
I would, so I'll jump in and, one, Karen does a fantastic job in laying this all out in that paper. It's very well done and provides a lot of guidance that I feel it can be used as a future reference. I'll probably be sending it out to all of my clients as a newsletter edition. So I really, if you're interested in this and want to learn more about how it all, the technicalities tie together, take a look there. But I will just jump back to the first point on this slide and it being saying, be mindful of the limits of your expertise. It may also be important too to consider the expertise of the other parties. So for example, in this case, the town, if you're the consultant and you're speaking to the town about building a dam, and some red flags go off indicating that they don't really have a lot of expertise in building a dam, that could raise some red flags for you to be more diligent in your project risk analysis or in strategizing on how you want to proceed with the client that has limited expertise in that kind of project type.
Yeah, that's a really good point. Yeah, I mean, I think that goes with all types of issues on construction projects. Like if a consultant knows that a contractor has particular expertise, maybe they don't necessarily have to do field review quite as frequently as they otherwise would if they didn't necessarily trust the contractor or know their level of expertise. So that's an excellent point. And so the last issue that comes up in that case study is the standard of care. So we've talked about that, and the question that I've asked here is, does the standard of care vary depending upon the risks associated with the project? So a dam is obviously a very large, significant project that presents potential safety risks and potential for damage to a large number of people and extensive property damage. So the answer to that is not really. It's a typical lawyer answer. The standard of care is always the same. What is required is the exercise of reasonable skill, care, and diligence. So that's the standard. But because of the complexity of the project, arguably the level of skill, care, and diligence that is required is more than it would be for a simple, less complex project. So it may vary just because of that. And implicit in the standard of care is the duty to stay current in the field. So you should obviously recognize the limits of your expertise, as Rob mentioned, and the limits of the expertise of other people on the project as well. So the last case study that we're going to go through, this was, again, taken from a real life scenario. I've changed it up a little bit and added a couple other dimensions just to illustrate a few points. So in this one, the project involved the installation of a water system through a problematic soil. The geotechnical engineer provided advice as to the nature of the soil conditions and suggested to the owner that PVC pipe could be used. And the PVC pipe suggestion was made because it was less expensive than the preferred pipe material, which was cast iron pipe. So the engineer knew that the cast iron would be better performing, but he was trying to save the owner some money by recommending the PVC pipe. And so the geotechnical report recommended the use of PVC pipe. And the geotechnical report contained a disclaimer clause, which basically said, I disclaim any representation warranty. I'm not liable for anything. I'm not negligent for anything. You can't sue me for anything. The typical kind of broad disclaimer, also fondly called a weasel clause. So that was in there. And then after the PVC pipe was installed, it moved due to soil conditions and it broke. There was an unsuccessful attempt to repair the pipe. And ultimately, it had to be replaced with the cast iron pipe, which was the original better recommendation. So again, not surprisingly, the engineer was sued for negligent design and advice and the cost of having to remove the PVC pipe and put in the cast iron pipe. The owner argued that he relied entirely upon the engineer's advice, and the engineer said, "No, I'm relying on a disclaimer in the geotechnical report." So this example case study raises a few issues. The first is how to avoid the unwitting assumptions of risk that should stay with the property owner. So one of the ways that a geotechnical consultant can unwittingly assume the property risks is by not giving their client all the advice that they need in order to make the appropriate decisions here. So in this particular case, the owner, maybe the developer, purchased the property on a speculative basis without any knowledge as to the nature or the condition of the property. They're relying upon the geotechnical engineer to perform the appropriate subsurface testing to extrapolate the nature of the site and provide a report as to that. And throughout this process, you as the consultant want the risks to remain with the owner developer. So the owner and the developer should be the one making the decisions with respect to the property and having the knowledge to make those decisions. The paper refers to the example case of the District of Surrey and Carroll Hatch, which is a case I think that is probably well known. It's decided quite a long time ago now, but it involved a site where the structural engineer recommended to the architect that a soils report be retained or obtained. The architect thought the owner wouldn't want to pay for it, so the architect said no. The structural engineer provided what they called a form of soils report, which was wrong. Damage resulted when they constructed on the soil, and the architect and the structural engineer were found to be negligent. It's obviously more nuanced than that. I'm summarizing it. But in that situation, had the architect and the structural engineer provided the proper advice to the owner would have had that knowledge and made those decisions as to whether a soils report was required. So the owner would have been the one that kept that risk and would have been the one making the decisions. So that's the point of that. And then the other issue that's raised by this case study is whether the disclaimer in the report is enforceable. And I often see these, they're attached to reports and drawings, and they're often raised in claims as defenses. And there's case law, and the case is cited in the paper, which says that this type of disclaimer is not enforceable because it's a type of limitation of liability. And when you have a limitation of liability, it has to be included in the original agreement between the parties. So you can't enter into an agreement and then subsequently say, oh, hey, by the way, I'm not responsible for this. So yeah, the parties have to agree up front as to what each person's respective liability is going to be or how it's going to be limited. So these types of disclaimers that are added to reports wouldn't be enforceable.
But so in those situations, Karen, or, if maybe the scope of the project changes or somebody's, in this case, they're, the engineer in hindsight should have, initially recommended that the cast iron pipe be used, and then maybe the owner or the contractor proposes using the PVC piping, and the consultant doesn't agree with it. When something like that changes on a project, how can a consultant, address that issue? Because in a lot of circumstances, I just don't see it, a lot of consultants being in a position to go back to change the contract.
Yeah, I think you have to obviously be aware of that issue and be mindful of that as it comes up. I think a lot of times when these projects are happening, these decisions are probably being made frequently, and people don't necessarily turn their mind to the potential for addending or amending the contract at an addendum, or varying the terms somehow, or coming to some sort of agreement to amend that to add a limitation of liability with respect to that particular term. So it depends on the contract and what the parties are willing to agree to. But I think if people are alive to these issues, then at least they can raise them and try to get those amendments included.
Is there some, if somebody's proposing, an inferior substitution as the project goes along? Or is there a way for the consultants to raise concerns or voice concerns that can protect them kind of like in the natural flow of the project without making a big deal to go back and change the contract?
Yeah, for sure. I mean, you don't necessarily have to change the contract if there's a material substitution, and I mean, you have to change the contract if you wanted to have an enforceable limitation of liability. But I'm not suggesting that you should change the contract just if there's a material specification. But if you have some sort of change and say you're not necessarily 100% behind that material specification change, yes, then you could provide a letter documenting your concerns, put it in the meeting minutes, send emails. Like I said, you've said before, it doesn't necessarily have to be confrontational. It's just that this is a concern. I have a concern about the performance or the suitability of this material in the particular context of this project, and just document it. I mean, I think that maybe the number one takeaway point here for people is that it would be nice to try to prevent claims from happening, but it's fairly hard to do that and almost impossible in some circumstances. So what you want to do is to conduct the project in such a way to arm yourself with the best defense possible and say, look, I did everything that I could have possibly done in the circumstances to warn the owner, to warn the client, and provide clear advice. And I made these recommendations and they decided on their own to go ahead and make those decisions.
And this is where I come into play a lot with my clients. And so in the beginning, I said we help people address unique circumstances on the go. And so I think what a lot of consultants may not realize out there, there's a few good professional liability insurance providers that truly believe in working with their clients to help them prevent actual claims from occurring. And so some insurance providers call this PreClaimed Service or advice. And so essentially, a client might give me a call because they're in a unique circumstance that's new and unfamiliar to them. And they might just say, hey, Rob, have you seen this before? Or, we're a little concerned about this. There's no claim right now, but what can we do to respond? What strategies can we use? And, maybe I have some advice, but, more often than not, will report the issue to their insurance provider as a loss prevention issue. And that's enough for the insurance provider to get the firm in touch with a claim specialist that will walk through the circumstance with them and determine some options to consider to proceed to hopefully avoid an actual claim from occurring and to finish the project successfully while maintaining the relationship with the client. And a lot of the time it involves, drafting some type of correspondence. Maybe it's an email, maybe it's a letter to the appropriate members of the construction team, just laying out their position and potential options for proceeding. And using your insurance company and using that service that the insurance company provides generally does not impact your insurance premium or your claim history. It's in everyone's best interest to avoid a claim. That's why they provide the service. They're not going to turn around and say, you used that service a number of times last year and we're going to hike your premium up. It's a value add. And the clients that I have that use that service end up using it more and more because it's a tool for them and it's a resource to help address these circumstances as they arise.
Yeah, I agree with that. It's definitely helpful to sort of nip these things in the bud. And if you can stop something from becoming a litigated matter, it's definitely going to be less expensive in the long haul. And I have had success getting involved early before an action is commenced and resolving things short of that. So that sort of is a nice segue into our next section, which we'll just sort of deal with in a couple of minutes because we want to leave a few minutes for questions. I'm mindful of the time. Just dealing with claims management. And again, this is just discussed a little bit more detail in the paper. So Rob has talked about how to report a claim. So that's always helpful. And then this is more probably just advice to consultants on how to help your lawyer and how to make sure that the claim is handled in a way that that is the most efficient and effective. So the insurer will generally appoint defense counsel on your behalf. Under most policies, the insured is not entitled to select their counsel. And I think in most instances, unless you get someone like Craig Wallace, who I understand spoke earlier, your lawyer is not going to be an engineer and will have limited knowledge of the technical engineering raised in your claim. So I always find it very helpful if insureds are able to provide me with detailed written responses on the allegations in the notice of civil claim, giving me technical background and sort of technical information on the issues that are raised. That assists me in understanding the allegations and formulating a theory of the defense. You need to make sure that you provide complete document disclosure to your lawyer in a timely fashion. If there's key documents, you may want to identify them for your lawyer and explain their significance, because if it's a technical issue and your lawyer is not an engineer, they may not necessarily pick that out or understand it. Having the client prepare chronologies of events for me, sort of cross-reference to documents, is very helpful. This can be a lot of work for the insured, but it can also save the lawyer a lot of time and energy, and make sure that your defense is as focused as possible, which is key, because you want the lawyer to know about the claim and understand the claim as early as possible, because then the insurer will understand it, the other side will understand it, and ideally it will be resolved sooner. And then if there are any other parties in the litigation or not named in the litigation that should be, tell your lawyer and help them identify documents that may identify those people, because they should be potentially added as third parties. There's a strict 2-year limitation period to add third parties to a claim. So that's kind of just a very brief overview of how to help your lawyer defend your claim. And then so just rounding out our comments, as I mentioned earlier, it's difficult to entirely eliminate risks. There's a lot more that can be talked about on the risk management side, like the use of indemnity clauses and contractual terms. I actually, as a side note, teach a 2-day course on that issue. So there's a lot to talk about. So if people have questions, I'm happy to have further discussion. But the upshot of that is that you can manage and transfer risk, but it doesn't necessarily prevent claims from happening. So you want to try to deal with the project in the best way possible so that you afford yourself the best defense when the claim does arise. Rob, any concluding comments?
No, maybe let's just jump to questions given the time.
Yeah.
Great. Thanks so much, Karen and Rob, for that great presentation. I think it's a great complement to the discussion we had this morning with Craig Wallace, and how can we not go visit Craig, and how can we not go visit Karen, essentially.
Yeah.
Things go wrong. Not too often speakers, as we've been saying, like dissuade you from visiting them. At the moment online, we don't have any questions right now. But as we alluded to before, Karen and Rob will be joining us in the panel discussion this afternoon. So if attendees have any overarching questions or maybe questions that relate to Craig's discussion as well, please put them in the discussion, and then they'll be discussed during the panel discussion.
Thank you, Shane.
Yep.
Thank you very much. Thanks, Shane. Thanks, everyone.
Thanks, Karen. Thanks, Rob.
See you later.
See you
Bye.
later.